This video will summarize the process of care proceedings and what you need to know to be successful when the local authority becomes involved with your children.
Hi, I'm Chris Aniche, an accredited Children and Family Law Panel Solicitor. I'll be explaining in summary procedures from start to finish to enable you grasp the nitty-gritty of this complex area of law.
When the local authority commences proceedings seeking to remove children from their parents' care, this basically is how the case flows in court from start to finish. Starting with the application. After the local authority would have completed their legal planning meeting, and in many occasions the public law outline meeting, also known as the PLO meeting, where they will inform the parents that they now wish to engage the court due to the seriousness of the case.
The first step the local authority must take in order to start care proceeding is that they need to make an application to the local family court. That is where the child lives, or where the child and the parents live, to commence care proceedings.
The application form is Form C-100, and the local authority must complete all the relevant sections of the form. For example, information like details of the children they are worried about and the dates of birth. There are different dates of birth. Details of the parents or the caregiver. The reasons why they are making the application, what plans they think are the best plans for the child or children, which court order they need to put the plan into action, whether an urgent hearing is needed or required.
The application made by the local authority will now be considered by the court, and if the court finds that the local authority has duly completed the form properly, submitted all the right papers, and paid the correct fees, the court will issue it and list the case for a hearing.
Turning to the first hearing. The case in court. When the social services has asked for a care order for your child from the court can only grant an interim care order first if the interim threshold has been crossed under Section 38(2) of the Children's Act of 1989. I have previously discussed about interim threshold in one of my earlier videos. Please do check it out. So, assuming the court makes the order, it will give the local authority parental responsibility immediately under the law. Parental responsibility means that they have the rights, duties, and responsibility of a parent same as you, although for their case, they are in the driver's seat. For instance, a person with parental responsibility would decide where the child lives and who he or she sees, etc. The person with PR can also decide about child's education, religion, medical care, etc. Mother always have the parental responsibility for their children. Please note, not all fathers have parental responsibility. A lot of fathers have PRO automatically, while others will need to apply for it. I will discuss about parental responsibility in another of my videos.
When the local authority obtains an interim care order, they take the driver's seat. That is, they are in the driving seat over that of the parent's PRO. They can decide if the child should stay in the foster care for a while instead of with you as the parents, because they are in the driver's seat. They can also make critical decisions which you may not even agree with, as the parents of the child because they have obtained interim care order or care order at the conclusion of the proceedings.
Duration of care order. Generally, a care order stays in place until the child turns 18 years, if not discharged before then, while the supervision order does not give the social services PRO. When a supervision order is in place, you are only as a parent responsible for making the decision for your child or children, not the local authority or the social services, such as when they have the care order in place. When a supervision order, the local authority can only do one thing. They can assist, befriend, and advise you on how best to safeguard your child. First hearing. The first hearing will probably take place at a local family court in the area. During the first hearing, the local authority may ask the court to give them parental responsibility through an interim care order, which is, like I indicated earlier on, is a short-term or temporal order. This usually means that social services want to share parental responsibility with the parents and may want your child to be placed in a foster care while they investigate the case in more detail. Sometimes social services will let a relative or friend watch your child while the investigations are ongoing. Other times, the court may say that your child can stay at home with you while the investigations are ongoing. However, all of this depends on how serious the court thinks the risk to your child might be staying with you. Who should be in court? Parties or people who are usually in court during the first hearing are the social worker, a lawyer from the social services, the mother and her legal advocate or barrister or solicitor, the father of the child if he has been notified, most especially if he has parental responsibility, and also his lawyer. If by that time a child guardian is appointed, he or she will also be there with his solicitor or advocate. Child guardian. The child guardian is from Kafka's. He or she will be a social worker who is not part of the social services or the local authority. It will be his or her job to look out for your child's best interest in court, and he or she is the voice of your child.
The court will want to know what the child wants and how he or she feels. So the children guardian will talk to the child, and if the child is old enough and could make sure that the court hears his or her say what the child says, that is the child's wishes and feeling. The court will pay more attention to what the child wants and the older he or she is. Please note, you should work with the guardian since the court will put a lot of weight on his or her opinion when making a final decision about the child.
Court direction. At the first hearing, the court will decide whether or not your child should stay with you. While full investigations are conducted, the court will also give direction about what needs to be done to progress the case. Directions are orders from the court telling people involved in the case of what to do to move the case forward. It will include telling people about sending more proof about certain things to the court. As a parent, you will probably be asked to write a statement about what you think social services is saying and what you want the court to do. Court's timetable.
This is the time or the duration the case should take, or when the direction or court order should be complied with. Care proceedings should usually take 26 weeks. However, it can take longer or shorter depending on the complexities and some other factors.
Turning to interim care order, as I indicated earlier on, if the court issues an interim care order, the social service will be able to make decisions about your child because they now have parental responsibility. This could mean that your child will stay in foster care for some long time, being until a subsequent order has been made by the court. And that subsequent order may be an order saying the child should return back home in the interim before a final decision or the final hearing. Contact. If the court agrees that your child should stay in foster care, for instance, while investigations are done, social services must let your child see you unless the court says there should be no contact at all. But this is a very rare occasion. At the first court hearing, parties will likely talk about how much contact there should be and how they should be set up. Assessments. Assessments are a way to find out things in care cases, and it will assist the judge to make a final decision at the conclusion of the case. For example, in some cases, the court may tell you to be assessed by a psychologist, a psychiatrist, or any other expert relevant to the case. Threshold. In one of my previous videos, I discussed what a threshold was. There are two different parts to care proceedings. In the first part, social service has to show to the court that your child is in danger now or is likely to be danger in the future. This part of the law is very complicated.
Social services will need to convince the court why they think your child is in danger, and you will be able to respond to the evidence. If the court agrees that your child is in danger, this will mean that the matter has crossed the threshold for the making of an order sought by the local authority.
Interim care order under Section 38 of the Children's Act 1989. It states that the local authority shall not only make an interim care order or interim supervision order under this section unless it is satisfied that there are reasonable grounds for believing that the circumstances with respect to the child are as mentioned in Section 31(2). That is, the child has suffered or is at risk of suffering significant harm, and that is the threshold. Lord Justice McFarlane, delivering the main judgment in the Court of Appeal case in Re J, a child, 2015, EWC A CIV 222, clearly set out that threshold statement should be in a short and must clearly demonstrate the following: what the nature of the local authority case is, what the essential factual basis of the case is, what the evidence upon which the local authority relies to establish its case, what the local authority is asking the court and why. The local authority will need to set out all of this so that to make it very clear to the parents what the issues are. Turning to the issues resolutions hearing. After all the evidence has been gathered, IRH, or the issues resolutions hearing, is the hearing to see if issues in the case can be agreed or narrowed down or settled if everyone agrees to it. If not, a final hearing will be held shortly after the issues resolutions hearing. Final hearing. As the name indicates, this is the final hearing in care proceedings matter. The social services will say what they want to happen with your child at the end of the case. They might tell you that it's safe for your child to live with you again, or that a family or someone outside of your family should take care of your child. The children's guardian will also write a report which is called their final analysis about what he or she thinks is the best for your child. If you don't agree with the plan of the social services or even the guardian, children's guardian, you can challenge their decision at the final hearing, where you will be allowed to speak to the judge. At the final hearing, you may be cross-examined. That is, when other parties will ask you questions about the threshold, your child, the contact, the plan being put forward for your child. For example, after the opening speech, there will be a cross-examination, there will be submissions, final submissions by the various lawyers representing all the parties, including your own lawyer. The judge will now decide what is the best interest of the child by making a final decision, and the case will therefore conclude with the making of a final order. In conclusion,
I hope this video has assisted you to some little understanding of care proceeding and improved your knowledge of this technical area of children's law. My name again is Chris Aniche, a children panel and a family accredited solicitor with Collymore Solicitors and Advocates. Please like, share, subscribe to my channel. Thank you very much, and bye-bye.